Moving right along, our next speaker is Peter Crofts. Peter, I think, takes the prize this morning because he's been a lawyer for 31 years, which tops anyone else. Of that, 12 years as a barrister, but prior to that he was a chartered accountant at Deloitte. He's got a qualification in psychology, he's an accredited mediator, he's done some work with the National Crime Authority. There's pretty much no end to his skill set. He's particularly good with his accounting and business valuation and forensic background with technical things, and in my experience there's nothing more technical than superannuation, and he's come to talk to us today about superannuation, particularly the curly matters we deal with defined benefit funds.
Thanks, Paul. When Michael suggested this, he said that one of the things that we needed to remember was that we were talking to solicitors and we had to be helpful. Indeed, Paul was going to have a role, and Paul and I were opposed yesterday, and whilst we waited for Registrar Moser to make a decision, or more correctly, not make a decision because she told us to go out and sort it out ourselves, we worked out some questions that I might be able to answer. That sort of intrigued me. It was a bit like being interviewed as a sports star, and I thought that'd be lovely. Given the time, however, I thought I'd cut to the chase with a couple of things that are current, and then please, I'm very happy to take questions about the things that interest you. My first point really is about self-managed funds and non-self-managed funds. You appreciate that for non-self-managed funds there will inevitably be a regulation as to how they're to be valued. What we typically do is go off and get the most recent member statement, because the super fund has an obligation to provide member statements at least annually to its members. And we get that, and we look at what the what the current benefit is on that statement, and we say that's what we use as the value. Now, that's not a bad shorthand way, but to actually apply for a Form 6 has some advantages. It enables us to set the date. Now, if you are relying on the 2012 members statement, the stock market's leaped heaps since then. If there's $1 million in super, the stock market's gone up more than 10%. Even 1% is $10,000. If your client's getting 50% and it costs you $600 to get a Form 6, it's a pretty good investment, $600 to earn $5,000. Therefore, it seems to me that it is a well worthwhile exercise in a non-self-managed fund to actually take the time and trouble to get a Form 6 and to set a date during the course of the running of the case or the preparation of the case that suits you. Some people worry, I shouldn't do that. He'll know that I'm checking on me. You'll all be aware that 90MZB6 says the super fund can't tell the member that the application's been made. So it's a really simple, nice way to get extra information that might help you. Of course, with a self-managed fund, there aren't regulations as to how it's to be valued. You've got to do it yourself. And again, typically, we simply get hold of the last annual financial accounts and tend to accept those. But of course, it's like any business valuation, except this is a business that would normally be valued on net tangible assets. It's what's invested. And there'll be a property interest somewhere, and there'll be some paintings, and there'll be a wine collection and an old car collection and all sorts of other things. And I'm sorry, the only real way to value it is to get them all valued. Now, it's a question of whether the cost's worth the effort, because the court doesn't have to have a valuation for a self-managed super fund. The parties can simply agree. But you need to go back and look at how the audit's been performed at the super fund and what the values that are accepted were. In theory, the auditors will have ensured that they are valued to market every year. In practice, very few do, particularly for things like properties. They remain in there at cost. The law changed. One of the issues I should skip through, or at least mention, the ATO has a wonderful website dealing with lost super. Not only your clients, but the other side's. It's a really quick little search for your secretary or someone to do. It's really nice when you turn up 20 or 30,000 that the other side have forgotten and left off their statement of financial circumstances, and which you've just added to the pool. It's worth doing. One of the changes that's been made in the, I suppose, crackdown on self-managed super, and if you read the papers, you can make up your own mind whether that crackdown is driven by the ATO and the massive non-compliance with people investing in all sorts of things they shouldn't, or whether it's really driven by big super who don't want the proliferation of small funds that currently exist. But one of those changes is that as from 1 July this year, trustees, whether trustees personally or trustees as directors, will be personally responsible for non-compliance of the fund. Now, non-compliance largely arises, A, under the SIS Act and regulations, where the wrong people are met, or the members of the self-managed fund are not all directors or trustees, or in terms of payments being made to people when they shouldn't be because they haven't qualified in age or otherwise, or because the investment strategies are in prohibited investments to obtain relevant tax deductions. And typically those will be in property, in things that are used by the members of the fund or by their families. So the beach house is in the super fund, but we rent it to ourselves or don't even bother renting it. The ATO is currently taking the view that if there is non-compliance and it can be rectified, and is rectified promptly, then there will largely be no penalty and nothing will happen. That means that for self-managed funds, you now have an issue of looking at whether the fund is complying and what needs to be done to fix it during your course of conducting the litigation, because preferably you want it fixed. You want it fixed without penalty, because if you don't get it fixed, your only real way of dealing with it is to include some form of indemnity, which really can't be an indemnity in the standard sense. It's got to be a promise or an order requiring the trustee keeping the self-managed fund to meet any civil penalties levied against the trustee leaving the self-managed fund. And quite bluntly, I wouldn't be allowing my client to give such an indemnity, and I'm not very confident that a court will order it either. Both these parties were trustees, both of them, as they must be in a self-managed fund, both of them had the ability to attend to matters, both of them should be responsible. And I think that's the outcome that will probably be pushed by the courts. So I think you've now got an obligation to start looking at what you can do to patch up those funds as fast as possible. You'll be aware, you'll appreciate that what we tend to do is come up with splitting orders, either in terms of a base amount or in terms of a percentage. There is the provision under Section 90MT to actually set your own calculation, but you can't do that in a court order. You've got to do it in a financial agreement. And that's particularly relevant where you might be concerned about the way that the valuation or the result of the valuation. The courts have been and have found ways to get around incorrect valuations, or when I say incorrect, perhaps unusual valuations. In BAR and JMR, which was a 2012 decision of Justice Young, the super fund was in pension phase. It had been valued by the valuer pursuant to the regulations, but he went on to express the view that that wasn't fair and that really he felt it was worth $130,000 more. Young took the view that he had to accept the valuation per the regulations, but he took the $130,000 the evidence of an extra $130,000 into consideration as a 75-2 F and O factor. That same approach was used much earlier by Coleman in a decision of Carhill in 2006. There was a super fund in pension phase. $1,000 a week was being paid to husband, and if I can find the quote, Coleman says, and I think we all see an element of sense in this. It's one thing to treat superannuation as property, to enliven the jurisdiction of the court to make an order in respect of superannuation, but another altogether to suggest that superannuation must be treated the same way as existing tangible assets. And particularly when you're looking at pension or amounts in pension phase or defined benefit schemes, the valuation is arrived at by looking at what an amount is needed now, put aside to meet the future income streams that you would have if you received the pension or the defined benefit from when you could get it until your expected demise, life tables. And they can amount to really big numbers that the individuals don't have. So is there another way to treat these, or how can they be treated? That goes to the final point I wanted to make in the time I had available, which was we have a tendency in Melbourne to just lump everything together. Super plus other assets equals pool, divide it or split it in a particular fashion. Paul made the point talking to me yesterday that that is very different to the approach in Sydney and Queensland, and it's absolutely correct. One of the things that we tend to forget is that we operate in an adversarial jurisdiction. It's up to us to come up with creative ways or creative issues as to why the pool should be treated differently, and to put those before the court. If we want to adopt the lazy way of putting everything together, the court's going to go along with us. Now, the fact that the pool should be considered separately is very clear. Doesn't mean that having considered it, you don't put it back. But the full court in McCulloch, 2006 family law cases, made that point. The judge had not considered the super pool separately. The full court said, no, you must at least turn your mind to it. The Western Green formula that used to exist prior to super splitting, in my view, remains good law. If there have been significant contributions prior to the commencement of the relationship, then Western Green gives you a methodology of saying, well, there was 5 years prior to the relationship, 10 years of relationship, therefore we'll take a third of the super pool out and only split 2/3. And again, no one's overturned it. Courts have applied it since super splitting, but you've got to apply the law to the facts that you've got. The concept of adjusting for post-separation contributions is not one that tends to find favour with the courts, because what you're really doing is putting aside monies, whether they be your wage or whether they be savings that would otherwise have been in the pool. So unless you can show that these contributions have come from some unusual event of your client, post-separation contributions will tend to be left in the super pool when splitting, and that's Marson is a decision of Mushin, which is now getting a bit old, but it's good authority for that point, I think. But the courts are quite prepared to be creative. If you look at the super deeds, there is often an ability when people are getting pensions in payment phase to commute it to a lump sum. Dusenberry, which is a 2011 decision of Austin, that was put to Austin, and he said, well, that's easy. I will make the husband commute it. I will order him to turn it into a lump sum. Then I've got a lump sum I can split very easily between husband and wife. So, there's the issue of discount for cash. We often forget that someone's keeping more super, but they're going to have to wait for it. So I think you need to pay as much attention to super as you do to other parts of the pool, and perhaps finally returning to the issue of getting the best for your client. It's worth considering whether you want a percentage order or a base amount, because of course if you split on percentage, you're always going to get a percentage of the contributions post the operative date but before the effective date, and particularly for self-managed funds where people are putting in big leaks. That can often be a very useful thing to get. I'll vary from all of that to one last issue, which comes out of a decision which was handed down recently by Justice McMillan, but not Justice McMillan of the Family Court, but Justice McMillan of the Supreme Court, and it was a decision relating to binding death benefit nominations. It's an important decision in the superannuation area because not only was the binding death benefit upheld, this was where the husband had died and left a binding death benefit nomination to his children, not to his second wife. And the second wife, as the member of the other member of the fund, became the trustee and challenged the binding death benefit nomination. Her Honour upheld the binding death benefit nomination, but went on to say that the trustee had fought the action not for the benefit of members, but for the benefit of the second wife, and therefore the trustee wasn't entitled to indemnity from the fund, as you would normally expect to be as a trustee, that the trustee was entitled to indemnity from the wife personally, because it was for her benefit the claim had been fought. What's important, however, was an argument raised on the binding death benefit nomination. You will appreciate that binding death benefit nominations do not expire on divorce or separation, so you need to have your clients change them as soon as they come along. But there was an interesting point raised on service. The SIS regulations at 6.16 talk about a trustee on receiving a binding death benefit nomination having to give notice to the donor if they regard that nomination as unacceptable or having problems. And 6.16.3, I think, talks about giving notice of a binding death benefit nomination to the trustee. One of the issues in this case was what constituted giving. Was it enough that a binding death benefit nomination was found in a file? But I think the lesson to be learnt, the thing that you need to do carefully if you are changing a binding death benefit nomination, is you need to make sure it is served. And that's not just sending it off to the accountant. If there is a corporate trustee, serve it on the registered office. If there are individual trustees, serve it on each of them. I'm very happy to take questions because I wasn't really sure which aspects of super would interest you all, and as I said, we'd prepared this as a tag team on questions, but given time, I foolishly told Paul I would just talk.
Since a reasonably well-known High Court case was handed down, what's your view about, in defined benefit funds, valuing effectively money that's owned by is capital that's federal government corpus, as opposed to money that's owned or in which the superannuant prospectively has an entitlement. It's not his money, it's not his capital, he can't grab it. Is that property to which the court can make an order, bearing in mind?
I think it is, given 90 MT and the following sections, which say that the court has the power to deal with it, and if valued, it will be effectively property. So if you valued it, you're stuck. I don't think we'll get very far trying to run arguments that this isn't real property, therefore the court can't deal with it. The clear intention of the legislature was that we should. The issue perhaps is, can we run arguments that it is inequitable in the fourth step, if we're still using 4 steps, to give to the husband something that he is only going to receive in the future, whereas the wife has all the current assets, and the way that the courts typically dealt with it is to recognise some form of discount for cash, that she's got the current assets and he's got to wait.
Peter, how do you quantify that discount for cash? Do you wheel in an actuary or an accountant? Or?
Depends whose side you're on. The courts have used figures varying from about 10 to 15%, so they're using comparatively small figures. In my view, if you wheeled in an actuary and did an argument about, in effect, the net present value of the future income stream, you'd end up with a much higher figure. So if you're on hubby's side, and this question of course comes from Paul, the matter that Paul and I were opposed in yesterday involves a large amount of super and he's on hubby's side, I'd be seriously considering getting an actuarial calculation.
And a related question, I've got another matter in which Peter's not opposed to me, where the parties have actually reached agreement. The husband has a very substantial defined benefit superannuation entitlement, and it's been valued by two solid valuers who've come up with pretty much the same figure, but the parties agree that the lump sum figure produced by the regulations is about half what it's really worth, in the sense of how much money you'd need even at 5% to generate this particular income stream for the rest of their life. And accordingly, the parties just agreed that they're going to give, in this case, the wife a bit more to compensate her for that fact. But I take it from this case of BAR and JMR, which I have no knowledge about, Justice Young's found a way of getting around that problem.
Yes, Young, always advantages in knowing the question first. Paul raised this with me yesterday, but the best I can find is Young's decision in BAR. Young took the view that he was bound by the valuation per the regs, but that the evidence of the parties that there was extra value was something he could adjust for as a 75-2 factor. So the court will always try and do what's just and equitable, so long as you get the point through to them, which goes back to thinking about how you present your case.
A question over here.
Sorry.
It's funny that you mentioned about the ATO lost super fund, because I've got a case at the moment where the other side wrote to me and said the husband has no recollection of which super funds he's in, but he values his superannuation at $30,000. Do I need the husband's tax file number to do the search for the lost superannuation?
It will be a much better search if you do. You can search on name alone, but the more information you get, date of birth, full name, past addresses, past employers, all improves the likelihood that you'll turn something up. Thank you very much. I was amazed that so few people walked out at coffee, given that superannuation was the last topic of the day.
Thank you very much, Pete. Just before we go, I'm interested in everyone else's view. One of the things we've been talking about in our office is that there seems to be a practice in Victoria where matters are settled that property will be split, non-superannuation property will be split 60, 40, 75, 25, whatever it may be, but superannuation is often aggregated, the two parties, total super, and then that ends up split so that they've got effectively the same amount. So effectively superannuation is split at 50-50, whereas the rest of the pool is split at a different amount. Whereas one of our lawyers has just come down from practising some years in Queensland and says in Queensland it's completely different. In Queensland they aggregate the super and divide it, but they divide it in the same proportions as they divide the rest of the pool. Has anyone else grappled with those issues? Does anyone have any thoughts about that?
I think it may have stemmed maybe from the first major decision, I don't know whether it was Hickey or not, where the full court, I believe, said super is property, but a different kind of property. Maybe that was the seed that sowed was the genesis for the view that, okay, we have a non-super pool and a super pool. But in theory, I can't see if it was property. It's property, but what you say in Victoria is universal, no matter how.
It's curious that we have a national system with Similarly, on relocation cases, I had a matter up in Sydney recently, and I was speaking to a barrister who's been at the bar up there for more than 30 years. He's one of the leading barristers. He said, Melbourne, they relocate on the drop of a hat. Sydney, it's a miracle if you can relocate to Wollongong. They just do not relocate the judges up there. They're all in the same court, and they've got a completely different attitude.
Find there aren't more appeals.
It's extraordinary, isn't it?
Yeah.
The registrars are pretty straightforward. It says 50-50 on the super, and they don't take kindly to arguments.
Yeah, it's curious, isn't it? When in another state with exactly the same law, they have an entirely different approach.
I think it could have something to do with the immediacy of the benefit, because if you do, like you might do a 60-40 on the hard assets, and it'd be unjust if it was like if you're still 20 years away from retirement, to do a 60-40 then on the super, it'd be unjust on the person with a greater amount of super, or the one who's getting this, the less amount. Whereas if you're only say 3 or 5 years away from retirement, the immediacy of that benefit is a lot sooner. So I think that's got a lot to do with the argument as well.
What's interesting with what Guy's saying there is this too, because when you're doing your 60-40 as an example, you've got below obviously for Section 75 2 factors, or shipping for Section 75 2 factors, which aren't necessarily going to exist when the parties retire in 20 years time.
That's exactly right.
Yes, you need to assess contribution needs on super in a different way than you do
Yes.
on non-super, and it may be the same, it may not be.
Well, maybe it's just that I'm Melbourne. I'm far more comfortable at a non-thinking gut level with the idea of 50-50. The prospect of dividing super 70-30 in some case seems to me, you just think, crikey, that's a bit much.
And,
But-
and if you introduce the Western Green argument as well,
Yes.
it becomes even more warped
Yes.
if you do it across the board. I think the way we do it here is a lot better, a lot more just and equitable.
We're leading the nation.
For what it's worth, if you go and look up CCH, they've got a nice little table of cases in this area. There are something of the order of 15 cases that say you don't split super and other assets the same, and only 5 that say you do.
Ah.
Well, those 15 probably been decided, in New South Wales and Queensland. Probably.
No, they aren't. There are decisions of Dessau, Brown, at least in the no you don't category, and the decisions of in favour of it are Warnick and Rose and federal magistrates.
So there goes that theory.
And the consent order procedure that you fill out requires you to split the total pool with super included in it.
Yes.
You've got to go through the explanation of the client quite a bit, whereas
Marty, that's drawn by bureaucrats, and we all hate that document. It's a crazy document. Does anyone have any questions of Joanne relating to evidence drafting?
Just one quick one. Affidavit, similar type of situation with criminal law and witness statements. It can be 12 months before it goes to trial. You get someone in the witness box, they add extra detail, they embellish. The immediate question is, this is an afterthought. Is it better to make the affidavits lean rather than include more weight?
I would, and for that very reason. And if you've practiced in the criminal area, you'll know that a traditional way of attacking and cross-examination is, witness, you've just told the court X, Y and Z, you didn't put that in your police statement, did you? And the response in re-examination is, well, no one told me I needed to go into that much detail. And I think you're a lot safer keeping it lean. If there is extra detail, it's often explained by an expansion. It's often elicited during cross-examination, and I think the situation's a little bit different rather than when someone's giving evidence in chief and expanding. But I think if you keep it lean, it's a lot safer in the sense that it's not contradictory, it's just more of an expansion, and the argument, well, it's just a recent invention, can be tidied up in re-examination when you ask, well, why did you include that extra detail that, perhaps an example, I kept using the drunk example, that he was drunk and then staggering around, vomited or whatever, and the witness will often say, well, no one asked me. And that's the way about it. You can tidy it up in re-examination as to what you were asked to do when you were drafting your affidavit. Well, I was asked to put down bare details. So I think it is always a problem, and it's even more of a problem when there's quite a different version. So if it's kept nice and tight, then less room to move, then less likely to fall into some traps later down the track. The only way to fix it up is the Band-Aid that can be applied in re-examination when the witness is asked, well, why didn't you put that in your affidavit? And hopefully they'll give the right answer.
It's problematic affidavits, isn't it? Because you go to court and sit there in the duty list and hear a circuit court judge or a family court judge bellyaching about this affidavit is far too long and I'm in a busy list and it's ridiculous that I'm buried with all this. And the next day you go along and sit in the same list and you hear the judge bellyache about this affidavit's manifestly inadequate, I don't have enough evidence, there's not... I think for solicitors it's a real challenge hitting that balance between having enough information so that the judge is not going to be critical of missing evidence that the judge wants and predicting what he or she may want, whilst at the same time not producing War and Peace. It's...
The Goldilocks.
Yes. Another question over here.
Is it better to bring on an application in a case to force the other party to redact certain parts of the affidavit that you believe are inadmissible, irrelevant, etc.? Or is it best to just run those arguments on whatever day it is that you happen to be in court?
I'd run them on the day in court for two reasons: money and time. And at the end of the day, it's the court that needs to make the ruling as to whether something's admissible or not. And it also gives your other side an opportunity, if you bring it on prior to then, to fix up some matters which may then make their case a bit stronger and a bit more watertight. Far better, I would say, tactically, to have the federal magistrate or the judge, as Cronin did, no matter, I had some years ago, he struck out every paragraph other than the first one, which stated the witness's name, and the last one, which basically said, I seek the orders contained in my application. And it was just a rambling mess. Far better that the judge does it, and then you've got the upper hand tactically. It also tends to make the judge more grumpy to the other side than your affidavit anyway. I don't know, other people might disagree with me, but I think it's their judge's job to sort of set the scene. I went to a seminar that was run by Chris Beale, of now SC, and he likened looking at evidence as, I don't know whether a few people are old enough here to remember the old Get Smart, where he goes through the various doors, and Chris said the very, very first door he goes through is relevance, and if you can't get through that door, you don't get into headquarters. So the door of relevance is the first starting point, and I think that's something just to keep in mind all the time.
If there are no other questions, we'll all run away to our important billable work. And can you join me in again thanking Peter and Joanne?